think, Marge. All I need is a title.
Okay, so after a couple weeks of speculation and wondering, the much anticipated Nunez Memo was released to the general public today. This memo is just over 3 pages, if you don't count the 2-page introduction written by the White House. It details information about the involvement of the FBI in the political campaign of 2016. I will now read the introduction and the memo to you in their entirety, and I will put the memo up on the screen so that you can follow along. I will withhold further comments until after the memo has been read. So this letter was written by the Honorable Donald F. McGahn II, written to the Honorable Devin Nunez, Chairman of the House Permanent Select Committee on Intelligence, the United States Capitol, Washington, D.C., 20515. Dear Mr. Chairman, on January 29, 2018, the House Permanent Select Committee on Intelligence, hereafter the committee, voted to disclose publicly a memorandum containing classified information provided to the committee in connection with its oversight activities. The memorandum, which is attached to this letter. As provided by Clause 11G of Rule 10 of the House of Representatives, the committee has forwarded this memorandum to the President based upon its determination that the release of the memorandum would serve the public interest. The Constitution vests the President with the authority to protect national security secrets from disclosure. As the Supreme Court has recognized, it is the President's responsibility to classify, declassify, and control access to information bearing on our intelligence sources and methods in national defense. See, for example, Department of the Navy versus Egan, and it also states a U.S. Code reference. In order to facilitate appropriate congressional oversight, the executive branch may entrust classified information to the appropriate committees of Congress, and it has done in connection with the committee's oversight activities here. The executive branch does so on the assumption that the committee will responsibly protect such classified information consistent with the laws of the United States. The committee has now determined that the release of the memorandum would be appropriate. The executive branch, across the administrations of both parties, has worked to accommodate congressional requests to declassify specific materials in the public interest. However, public release of the classified information by unilateral action of the legislative branch is extremely rare and raises significant separation of powers concerns. Accordingly, the committee's request to release the memorandum is interpreted as a request for declassification pursuant to the President's authority. The President understands that the protection of our national security represents his highest obligation. Accordingly, he has directed lawyers and national security staff to access the declassification request consistent with the established standards governing the handling of classified information, including those under Section 3.1d of Executive Order 13526. These standards permit declassification when the public interest in disclosure outweighs any need to protect the information. The White House review process also included input from the Office of the Director of National Intelligence and the Department of Justice. Consistent with this review and these standards, the President has determined that the declassification of the memorandum is appropriate. Based on this assessment and in light of the significant public interest in the memorandum, the President has authorized the declassification of the memorandum. To be clear, the memorandum reflects the judgment of its congressional authors. The President understands that oversight concerning matters relating to the memorandum may be continuing. Though the circumstances leading to the declassification through this process are extraordinary, the executive branch stands ready to work with Congress to accommodate oversight requests consistent with the applicable standards and processes, including the need to protect intelligence sources and methods. And it is signed, sincerely, Donald F. McGahn II, Counsel to the President. It was copied to the Speaker of the House of Representatives, Mr. Paul Ryan, and the Honorable Adam Schiff, ranking Democrat member of the House Permanent Select Committee on Intelligence. Now to the memo itself, which was dated January 18, 2018. The memo was sent to the House Permanent Select Committee on Intelligence majority members from the House Permanent Select Committee on Intelligence majority staff. And the subject was Foreign Intelligence Surveillance Act abuses at the Department of Justice and the Federal Bureau of Investigation. So under the first section entitled Purpose, this memorandum provides members an update on significant facts relating to the committee's ongoing investigation into the Department of Justice and the Federal Bureau of Investigation, and their use of the Foreign Intelligence Surveillance Act during the 2016 presidential election cycle. Our findings, which are detailed below: 1. Raise concerns with the legitimacy and legality of certain DOJ and FBI interactions with the Foreign Intelligence Surveillance Court, and 2. Represent a troubling breakdown of legal processes established to protect the American people from abuses related to the FISA process. The next section, Investigation Update. On October 21, 2016, the DOJ and FBI sought and received a FISA probable cause order, not under Title VII, authorizing electronic surveillance on Carter Page from the FISC, that's the court. Page is a U.S. citizen who served as a volunteer advisor to the Trump presidential campaign. Consistent with requirements under FISA, the application had to be first certified by the Director or Deputy Director of the FBI. It then required the approval of the Attorney General, Deputy Attorney General, or the Senate-confirmed Assistant Attorney General for the National Security Division. The FBI and DOJ obtained one initial FISA warrant targeting Carter Page and 3 FISA renewals from the FISA court. As required by statute, and it states the statute, a FISA order on an American citizen must be renewed by the FISA court every 90 days, and each renewal requires a separate finding of probable cause. Then Director James Comey signed 3 FISA applications in question on behalf of the FBI, and Deputy Director Andrew McCabe signed 1. Then Deputy Attorney General Sally Yates, then Acting Deputy Attorney General Dana Pointe, and Deputy Attorney General Rod Rosenstein each signed 1 or more FISA applications on behalf of the Department of Justice. Due to the sensitive nature of foreign intelligence activity, FISA submissions, including renewals, before the FISA court are classified. As such, the public's confidence in the integrity of the FISA process depends on the court's ability to hold the government to the highest standards, particularly as it relates to surveillance of American citizens. However, the FISA court's rigor in protecting the rights of Americans, which is reinforced by 90-day renewals of surveillance orders, is necessarily dependent on the government's production to the court of all materials and relevant facts. This should include information potentially favorable to the target of the FISA application that is known by the government. In the case of Carter Page, the government had at least 4 independent opportunities before the FISA court to accurately provide an accounting of the relevant facts. However, our findings indicate that, as described below, materials and relevant information was omitted. 1. The dossier, compiled by Christopher Steele, to be referred to as the Steele dossier, on behalf of the Democratic National Committee and the Hillary Clinton campaign, formed an essential part of the Carter Page FISA application. Steele was a longtime FBI source who was paid over $1,600,000 by the DNC and Clinton campaign through the law firm Perkins Coie and research from Fusion GPS to obtain derogatory information on Donald Trump's ties to Russia. A. Neither the initial application on October 2016 nor any of the renewals disclose or reference the role of the DNC, the Clinton campaign, or any party campaign in funding Steele's effort, even though the political origins of the Steele dossier were then known to senior DOJ and FBI officials. The initial FISA application notes that Steele was working for a named U.S. person, but does not name Fusion GPS and its principal, Glenn Simpson, who was paid by a U.S. law firm, Perkins Coie, representing the DNC, even though it was known by the DOJ at that time that political actors were involved in the Steele dossier. The application does not mention Steele was ultimately working on behalf of and paid by the DNC and the Clinton campaign, or that the FBI had separately authorized payment to Steele for the same information. Point 2. The Carter Page FISA application also cited extensively a September 23, 2016 Yahoo News article by Michael Isakov, which focuses on Page's July 2016 trip to Moscow. Note, the article does not corroborate the Steele dossier because it was derived from information leaked by Steele himself to Yahoo News. The Page FISA application incorrectly assesses that Steele did not directly provide information to Yahoo News. Steele has admitted in British court findings that he met with Yahoo News and several other outlets in September 2016 at the direction of Fusion GPS, Perkins Coie was aware of Steele's initial media contacts because they hosted at least one meeting in Washington, D.C. in 2016 with Steele and Fusion GPS where this matter was discussed. Steele was suspended and then terminated as an FBI source for what the FBI defined as the most serious of violations, an unauthorized disclosure to the media of his relationship with the FBI in an October 30th, 2016 Mother Jones article by David Korn. Steele should have been terminated for his previous undisclosed contacts with Yahoo and other outlets in September, before the Page application was submitted to the FISA court in October, but Steele improperly concealed from and lied to the FBI about these contacts. B. Steele's numerous encounters with the media violated the cardinal rule of source handling, maintaining confidentiality, and demonstrated that Steele had become a less than reliable source for the FBI. Point 3. Before and after Steele was terminated as a source, he maintained contact with the DOJ through the Associate Deputy Attorney General Bruce Orr, a senior DOJ official who worked closely with Deputy Attorney Generals Yates and later Rosenstein. Shortly after the election, the FBI began interviewing Orr, documenting his communications with Steele. For example, in September 2016, Steele admitted to Orr his feelings against then-candidate Trump, when Steele said he, quote, was desperate that Donald Trump not get elected and was passionate about him not being president. This clear evidence of Steele's bias was recorded by Orr at the time and subsequently in official FBI files, but not reflected in any of the Page FISA applications. During the same time period, Orr's wife was employed by Fusion GPS to assist in the cultivation of opposition research on Trump. Orr later provided the FBI with all of his wife's opposition research, paid for by the DNC and Clinton campaign through Fusion GPS. The Orr's relationship with Steele and Fusion GPS was inexplicably concealed from the FISA court. Point 4. According to the head of the FBI's Counterintelligence Division, Assistant Director Bill Priestep, corroboration of the Steele dossier was in its infancy at the time of the initial Page FISA application. After Steele was terminated, a source validation report conducted by an independent unit within the FBI assessed Steele's reporting as only minimally corroborated. Yet in early January 2017, Director Comey briefed President-elect Trump on a summary of the Steele dossier, even though it was, according to his June 2017 testimony, salacious and unverified. While the FISA application relied on Steele's past record of credible reporting on other unrelated matters, it ignored or concealed his anti-Trump financial and ideological motivations. Furthermore, Deputy Director McCabe testified before the committee in December 2017 that no surveillance warrant would have been sought from the FISA court without the Steele dossier information. Point 5. The Page FISA application also mentions information regarding fellow Trump campaign advisor George Papadopoulos, but there is no evidence of any cooperation or conspiracy between Page and Papadopoulos. The Papadopoulos information triggered the opening of an FBI counterintelligence investigation in late July 2016 by FBI agent Peter Strzok. Strzok, who was reassigned by the Special Counsel's Office to FBI Human Resources for improper text messaging with his mistress, FBI attorney Lisa Page, no known relationship to Carter Page, where they both demonstrated a clear bias against Trump and in favor of Clinton, whom Strzok had also investigated. The Strzok-Lisa Page texts also reflect extensive discussions about the investigation, orchestrating leaks to the media, and include a meeting with Deputy Director McCabe to discuss an insurance policy against Trump's election. Now that we have read the memo, let's get some perspectives on what it means for the FBI, the Department of Justice, and the Mueller investigation.
I want to dive right into the topic of the moment, and that is this memo. The president said it totally vindicates him and that this Russia probe is all just a witch hunt. Is he right?
I would say this, I'm sure the president is frustrated. Adam Schiff prejudged the investigation before we interviewed the first witness. So I'm sure that instructs some of what he said. I actually don't think it has any impact on the Russia probe for this reason.
The memo has no impact on the Russia probe.
Not to me it doesn't, and I was pretty integrally involved in the drafting of it. There is a Russia investigation without a dossier. So to the extent the memo deals with the dossier and the FISA process, the dossier has nothing to do with the meeting at Trump Tower. The dossier has nothing to do with an email sent by Cambridge Analytica. The dossier really has nothing to do with George Papadopoulos' meeting in Great Britain. It also doesn't have anything to do with obstruction of justice. So there's going to be a Russia probe even without a dossier.
The problem is that, as the end of this paragraph states, there would be no FISA surveillance warrant on the matter of the Trump campaign and possible collusion with Russia if it were not for the information contained in the Steele dossier, a package of materials we now know was nothing but lies and propaganda, put together by the Russians and paid for by the Hillary Clinton campaign and the DNC to either smear the Trump campaign or, in the unlikely event of a Trump victory, to do significant damage to the Trump presidency. Without the FISA surveillance warrant, would there have been a special prosecutor?
President Trump shared his thoughts on the memo from the Oval Office today, moments before it was released.
I think it's terrible. You want to know the truth? I think it's a disgrace. What's going on in this country, I think it's a disgrace. What's going on, a lot of people should be ashamed of themselves, and much worse than that. Let's see what happens. But a lot of people should be ashamed. Thank you very much.
All right, we'll take it around the table, starting with Kimberly, who knows a lot about the FBI process and getting a FISA warrant and all that goes into it. Your thoughts?
Yeah, there was a few things that jumped out to me right away that are sort of like the exclamation points. And what I thought was interesting is that they excluded the political origins on the Steele dossier that were known to senior DOJ and FBI officials, but they were left out and excluded from the FISA applications. And I feel that that in and of itself is sort of glaring because it shows like the motive, the intention, an intent to deceive, some duplicity on their part, which I think is totally inappropriate in terms of what they were supposed to be transparent about and put forward and proffer in terms of supporting documentation and what they knew. And if they knew about the political origins of it, that in and of itself should have cast doubt on the credibility. They purposefully withheld that information. So to me, that is a significant glaring factor. And probably it's like number one on my list, just about.
Juan, another part of it was that that the media helps play a role in this in a way. So apparently Steele leaked information about the dossier to Yahoo News. Yahoo News writes the article, and then apparently the FBI, when applying for the warrant, says that there was corroboration because it was in Yahoo News, but they didn't make it explicit that they had actually used their own, Steele used his own information to get it into the Yahoo News. What do you think of that?
Well, I don't think much of it. I mean, to me, it doesn't matter. Clearly, the FBI cut off contact with Steele once they suspected that he was leaking information. But this thing is so comical to me. I said to Greg in the green room, Greg, you're a seer, because this is zero. This is comical. I was thinking there's going to be something here, some element here that's really going to cause people to take a second look. Instead, you have a situation where Kimberly is talking about Steele having some political dislike for President Trump. That doesn't speak to the information in the memo. And secondly, guess what? It didn't even prompt the investigation. The investigation had started before with the news that the FBI had uncovered of George Papadopoulos' connection with Russian agents who were trying to win him over.
And that is included in the memo.
And so I don't understand. And then secondly, don't forget that Carter Page had been under FBI scrutiny since 2013, Dana. So again, this is not even pertinent. I mean, I don't get it. This, I'm struck by the number of Republicans who have said today, I'm thinking of John McCain, who said basically that Nunez and the Republicans here are doing Putin's work. John Kasich said it was an attack on American institutions and erodes our democracy. John Thune said we got to get past this. This is not good. I don't get it. And so President Trump says they're ashamed. He should be ashamed of using Nunez and the Congress in this way.
Well, Jesse, I'm assuming you think differently. Juan says he thinks it's comical, but you're not laughing.
I'm laughing at Juan's thesis. It's a kill shot. Juan knows it, so he's.
It's a kill shot.
It's an absolute
kill shot. Wow.
And the reason Juan can't admit it is because to admit it, he would have to admit that he's been wrong for a year on the whole hoax.
I get it.
They were caught red-handed in a conspiracy that the left accused the Republicans of being involved in. It involved the media. It involved Hillary operatives in foreign countries. It involved the Department of Justice and the FBI under Barack Obama. You say the FBI cut off contact with Steele after they caught him leaking. Then he backdoored through the Justice Department. And the person whhose wife was working for using GPS ended up being demoted, Bruce Orr. You say this didn't prompt the investigation. You know what did prompt the investigation?
Tell me.
Strzok. The Trump-hating, corrupt FBI official. So what's worse? You're also saying...
Excuse me, wait a second.
Yeah.
Strzok responded when Papadopoulos was found to being recruited by the Russians. And then he was subsequently taken off the investigation.
Okay, so he hates Trump. The fix was in. He cooked up the Hillary deal and then opens up an investigation on Papadopoulos off of some conversation over in London. That's not a big deal, Juan? To me, it is. You know what else is really interesting? No, listen, let me finish.
Someone like you is so desperate.
This is not desperation.
Oh, my God.
This is not desperation at all. Read the memo. I don't even think Juan's actually read the memo.
You guys, we got to get Greg in here.
Let's say, I want to say one thing that Kimberly said. Juan, if James Comey is signing off on 3 FISA application warrants, and he knows the application was based on a document, the dossier that was paid for by Hillary and was unverified and salacious, why would he do that?
Well, first of all, it wasn't based on, there's no indication this was the total basis for it. Everybody
Juan,
says.
they said if the dossier hadn't been there, they never would have gotten the application.
Again.
McCabe said it under oath.
No,
Juan.
Well, actually, did you not see the thing that Brett Baer sent earlier that said that the Democrats are disputing that McCabe didn't say those exact words? And so who knows, maybe when their memo comes out, Greg will have more information on that.
Well, you know, the thing is, since this whole thing started, this nerd Super Bowl, I said that I didn't think there was there was going to be a big deal. So I don't have a dog in this hunt. I'm not interested in being proven correct that nothing happened here. But when somebody says there's nothing to see here, that means there's something to see here, because there's always something, and it's clear when you look at this that there is something. And when you step back and you see this mosaic of malfeasance, when you see things like the tarmac and you see things like the servers and the text messages and the Comey statement, and then you see the political roots of this dossier and why the political roots of the dossier were covered up. Well, who would do that? Why would they do that? It stinks of Clinton. This is all about Hillary Clinton. I mean, this is to help her get elected. We spent the last year and a half hearing about collusion between Donald Trump and the Russians. And all along, the real collusion was committed by the perpetrators of that narrative. So if you look at the media, the Democrats and their allies in government, those are the people that have been colluding. They've been colluding about a narrative, and they were colluding before the election.
That's correct. When you look at the memo, you'll see the portion where Christopher Steele, an MI6 agent and British national, by the way, admits in September 2016 to Bruce Orr, another Clinton supporter, that he was, quote, desperate that Donald Trump not get elected, and he was passionate about him not being president. Then you had Peter Strzok and Lisa Page, 2 high-level FBI agents who talked amongst themselves, with Strzok saying that they needed an insurance policy against a Trump electoral victory. His communications with Page later show that he got involved with the Mueller investigation to finish what he had started with the Clinton investigation. Remember, it was Strzok who wrote the initial FBI statement about Hillary Clinton, exonerating her before she was even interviewed in the email probe. There is a lot more to this story, and I have been thinking about producing a video where I tie together all of the links from the Clinton email investigations, the Clinton campaign's attempts to rig the 2016 election campaign, and how all of that dumps into the Mueller investigation. Some things are very clear, however. Paul Manafort and Michael Flynn should immediately appeal their convictions, because these were the results of investigations brought about in part or in whole because of the flawed Steele dossier. Robert Mueller should at the very least suspend his probe until this matter can be straightened out, and the appropriate oversight authority should be directed by the president to make doing this their top priority. President Trump should not move to fire Mueller, but FBI Director Wray and Attorney General Sessions should use this memo as the motivation to clean their houses, and they can start by firing Peter Strzok, Bruce Orr, and others, and leveling charges against James Comey and Andrew McCabe for providing false information to obtain a FISA warrant, which is a crime under the FISA laws.